So for tonight, we're just going to focus a little bit more on personal planning. And what I'm going to sort of do today, we have a little bit of limited time, but what I'm going to do is sort of give you an overview of estate planning and go into sort of some of the tips on how to avoid common planning risks, some traps and pitfalls, what I've sort of often see in clients or clients' problems when they come to me. So just a basic summary of what we'll be covering. We'll go very quickly through what the benefits of planning are. A lot of them are common sense, so we won't spend too much time on that. And in BC, when we do planning, we often do planning in terms of consideration of two different stages. One is while the client is still alive. Often people forget about that. We need to consider some of the what-if scenarios. And the other one is what we call post-mortem, so if the client passes away. So we'll talk a little bit about incapacity planning. So that's planning for when the client is still alive. We plan for some of the what-if scenarios if something happens. And then we'll go into, a lot of people ask me about trusts. What are trusts? How can we use trusts? So trust is going to be a very complicated area, but I'll give everybody a little bit of a brief overview today. There are two main types of trust, and we'll talk a little bit about that, about the two different types, what each type is, what are some of the main uses of each one. We'll go into a little bit of will planning. Most people think of estate planning, they think of wills. And then we'll talk about probate as well. That's one of the very common questions that I get. What is probate? What is that process? Why do we need it? Why do I have to pay probate fees? Okay. And then we're going to get into some of the other types of planning tools that we can also use as well, in addition to wills. So we'll talk about beneficiary designations. A little bit about inter vivos trust, so that's one of the types of trust that I'll be going into, and then a couple of different other planning tools. And then we'll have a quick summary at the very end. Okay. So benefits of planning. This is quite common sense, but I thought this would be the best place to start. Give everybody an idea of why we should do planning. So first of all, we're going to talk about incapacity planning. If you're still alive but something happens to you, you have an accident, or the better scenario is you're off on a world holiday and something happens at home and you can't get back in time to deal with it. What do we do then? Okay, so we need to make sure that we have documentation in place to cover those scenarios. Other ones, nobody likes to pay taxes. Okay, so how do we create some value for clients and have some tax savings? So tax savings we can sometimes create during the client's lifetime and also for their beneficiaries or their family if something happens to them. Okay. We could also reduce taxes that are payable by the beneficiaries, by the family members when they receive the inheritance as well. Another one that is a very common goal of clients is asset protection for themselves and also for their beneficiaries. I can't say how many times I've heard from clients, I don't really like my son-in-law or daughter-in-law. I think they just want assets, right? Or they're worried if something happens to that relationship or marriage, how do I protect my child and the assets I'm going to give to my child? Estate planning is the way to do it. There's a lot of different ways, but you do have to consider them. Okay. And better ways to transfer wealth and to protect wealth, whether the client wants to transfer wealth now. In Vancouver, as part of the younger generation, is very difficult for the younger generation to buy their own home. So often they will borrow from the bank of mom and dad. So how do we do that in a way that will protect those assets or those gifts that we're giving to them now? Other thing, distribution. So how do you ensure that your estate and your assets are distributed the way that you want? Okay. How to avoid disputes and issues. Many people may think their family is perfect, but when somebody passes away, it's amazing how those relationships can change. Sometimes it's not necessarily the immediate family members, but it's the influences. So the spouse of the child will sort of pipe in at that point and say, well, why aren't you getting the same amount as your brother? Or why are you getting this, which is worth less than what he's getting? So that's when those influences can come in and when relationships can break down. And that way we want to make sure we try and avoid disputes and issues. And if you have a blended or complicated family, then that's even more important. Okay. Easier administration of estate. So for those who do have the, so to speak, perfect family, everybody gets along, it's the first marriage, there's still ways that we can use estate planning, and it's still important to do estate planning to make sure that we can make it easier for family members to deal with assets. And lastly, we want to avoid having the government, the public guardian and trustee, have to come in and deal with assets for our beneficiaries. Okay. So the first thing we want to talk about for estate planning is the first time period that we talked about. So incapacity planning. So this is while the client is still alive. Okay. There are a couple different legal documents that we can use. The most important is the enduring power of attorney. So this is something I will recommend to every single person who is an adult and who has assets in Canada. Whether or not you are if you're a tax resident or have any status in Canada, if you have an asset in Canada, it's very important to have enduring power of attorney. Okay. So what is an enduring power of attorney? So enduring power of attorney is a legal document where you can appoint somebody of your choosing, or more than one person if you wish, to be able to deal with your financial affairs. So that is anything to do with your assets, whether that's money, bank accounts, real estate, real property, your business if you have one, and also legal affairs if you have a lawsuit that happens or anything like that. So there was a new Power of Attorney Act that came in September 2011. My practice area is one of those areas that in the last couple years, there's been a lot of changes in the laws. So if you have done powers of attorneys or wills that were a little bit older, you may want to pull those out and make sure that they still work very well under the new law. Okay? One of the big changes for the Power of Attorney Act is under the old act, what we used to always do is for a client who may want to appoint, they have 2 children, one in BC, one in Ontario, they can appoint both children and say on the document who may act separately, meaning BC child or Ontario child, only one of them needs to sign. But now under the new Power of Attorney Act, that is no longer the case. Unless you specify what BC child can do, they can only deal with bank accounts, or Ontario child can only deal with your business. If you don't separate out the scope of their authority, it means that they have to act together. Okay? So that is a new change. So if no longer appropriate to appoint both children, maybe we will remove the Ontario child because it's much more difficult for them to come back here to deal with the parent's asset if something happens. Okay. So why are these powers of attorney so important? So they are fairly straightforward, simple documents. But if you don't have a legally signed, valid, enduring power of attorney, if you lose capacity, there is nobody that has any authority to sign or deal with your assets or financial affairs for you, not even a spouse. So a lot of people say, well, all of my assets are joint with my spouse. Why do I need a power of attorney? Well, all of your assets may be joint. So for a bank account, if one spouse has a medical emergency, is in a coma, they're incapable, the other spouse can still take money out of the joint account, but if anything needs to be signed on that account, the bank will require both signatures, and the spouse cannot sign for the incapacitated spouse. If your mortgage comes due on your home and you need to renew your mortgage or refinance your mortgage, you cannot sign for your spouse without enduring power of attorney. So if you don't have one, then what happens? It means that family members actually have to go to court to apply to get what we call a commutation. So that's a court order saying this person has legal authority to deal with assets or financial affairs for this incapacitated person. It can take quite a long time to get through court, and lawyer fees are not inexpensive. Okay. And the other thing is, if the family dynamics are more complicated, there may be more than one family member that applies to court. And the court judge will decide who is most appropriate. Or if the judge or court feels that nobody is really appropriate that's applied, they may actually say the public guardian and trustee should be involved. Or the public guardian and trustee may get involved and say we should be the one that's in charge of everything. And with the public guardian and trustee, they do charge fees for acting. They are not free, okay? And their decisions, it may be very impersonal and may not be consistent with what will work best for the family. Okay, so very, very important to have a power of attorney. So we talked about powers of attorney which deal with more assets and business and legal affairs. The other types of documents we have deal with medical and care decisions. Okay, so if the person loses capacity, what type of medical treatments do they undergo? Or if a client is more elderly, they have Alzheimer's, they lose capacity. Who will make decisions for them? Where do they live? What kind of care home do they live? Do they live at home, right? Do we have other caretakers? What kind of documents? We have 3 types of documents for medical decisions. So they range from one extreme to the other one. So on the more formal, very comprehensive side, we have the representation agreement. So this is a very formal, a little bit more lengthy document where you would appoint somebody to do a lot of your medical decisions for you, your care decisions, and it is you can list out all of the powers that you can give them. Okay. On the other end, we have what we call a living will. So to sort of put it a little bit bluntly, this is the die with dignity. So if a person has a terminal illness and they want to basically have quality of life for the remainder of their life, then this is where the living will sort of comes in. But this document is just a representation of the client's wishes. It is not legally binding. Okay, so that's the other side. And in the middle, we have an advance directive. So advance directive is not quite as comprehensive as a representation agreement, but it's a more legally binding version of a living will. But there are formal wording and signing requirements for that. Okay. All right, now getting into trust. So we have 2 main types of trusts. And again, it's separated sort of person's lifetime versus after they pass away. So the 2 main types of trust, now these are Latin words, so I'll just sort of explain what they are. So the first one is what we call testamentary trusts. So these are trusts that don't exist right now. We have to create the framework, create all the terms for that trust, but they don't come into existence until the person passes away. Okay? So the common ones that we see for testamentary trusts are in wills. If the person passes away, now their assets are being dealt with. And once they're ready to be distributed, we can set up terms in the will to say that it's now going to a minor child or some other beneficiary, and we want to put it into a trust. That trust is created at that time. Okay. The other times we see it is often for life insurance or other things that we can designate beneficiaries for, and we'll go in a little bit more into that a little bit later. But the important thing for this type of trust that it has to be, the words, the provisions for that trust have to be created now by the client before they pass away. They have to have those legal documents. They have to have the terms and everything set out in advance. Okay. If you don't, then the beneficiaries or the family can't just create their own testamentary trust later on. Okay. Inter vivos trust. So this is the other scenario. The client wants to set up a trust now. They want a trust that to exist now. They want assets to go in. That's what we call an inter vivos trust. So it's trust that's set up during a client's lifetime. Okay. So wills. So when we talk about the second time period when a client passes away, planning for post-mortem planning, most people think about wills. So wills are the simplest way to do post-mortem planning. Okay. But they're not always the best way to do post-mortem planning. They are the simplest, the easiest way, but they're not always the best way. Why is it not always the best way? Because one thing is wills variation claims. So in BC, if a person passes away and they have assets that go through a will, all the spouses and the children of that deceased person have the right to challenge the will if they feel the portion that they got was not fair. Okay? So that's a potentially very big risk to certain estates. right? If the client cuts out a child, or they give everything to the spouse and leave out the children, or if there's a second marriage, it's a blended family, it can become very messy. And if it does become a legal action, it takes years to go through. And what I tell clients is that essentially the lawyers, the litigators, become your beneficiaries. A lot of your assets are going to end up going to legal fees. Okay, that's just a reality, right? The other times when we might not use will planning is when we do alternative planning, and I'll talk a little bit more about those. But we may be doing planning to save on probate fees, to save some estate taxes, right? We might do other planning, so we may not necessarily rely on or use a will. So why do most people use a will? Why is it the easiest way of doing things? Because it can be a very straightforward document. In the document itself, you would appoint a trusted or multiple trusted executors or trustees. They are the ones that will manage the assets, do your tax returns, go through probate if necessary. Then once they're ready, they'll distribute based on the terms that you have in your will. If you have minor children, you could also appoint guardians in your will for them. Okay. We also talked about testamentary trusts. So you could always also set up testamentary trusts for your beneficiaries in the context of a will, right? It's very important when we do that we do that for minors or beneficiaries with legal disabilities, because if you don't do so, any amounts that go to a minor or a beneficiary with a legal disability will go to the public guardian and trustee to manage for that minor or beneficiary with a legal disability, even if there's a surviving spouse. Okay? And they charge fees, and for a minor, once the minor turns 19, they will get everything in cash. And I don't know if you remember when you were 19, but at 19, you may not be the most responsible to get a big amount of cash. The other reasons why testamentary trusts can be quite helpful, they can provide creditor or asset protection for the beneficiaries. Okay, so even if the beneficiary or the child is an adult and they are responsible, we're not worried about them spending all the money, we can still set up testamentary trusts for them. It's still actually quite a good idea. Any assets that we put into a trust for them is not considered the child's own asset. So we do get some protection for family law purpose. So if we're trying to avoid the gold digger son or daughter-in-law, right? Or if the child is a professional or a business owner, there's more risk for personal liability. This is a good way to do that, okay? And we also have possibilities to do some income splitting and also to save some taxes for them as well. So now, what is probate? So this is one of the very common questions I get. Now, probate is optional, but one of the big misconceptions that people have is that, oh, if I have a will, I don't have to go through probate. That is incorrect. So if you do have a will or not, whether you have to go through probate actually depends on what assets go through that estate. So any assets that are jointly held, okay, if it's a true joint tenancy, and we'll talk about joint tenancies, they will actually go to the surviving joint owner, doesn't go through the will or through the estate, doesn't have to go through probate. Anything where we're allowed and we have designated a beneficiary will also go outside of the estate, won't require probate. So what things require probate? So if the estate has any sort of bank accounts of any fairly significant value, and when I say significant value, sometimes even a few $1,000s, or you have any real property, real estate, okay? Sometimes cars, depending on how helpful ICBC is feeling. All of those assets, if there's any of those assets in the estate, then most likely you will require probate, okay? And why do we require probate for those? Well, if the family members actually want to deal with those assets and transfer those assets, they will require probate. Because if they go to the bank, if they go to the land title office, if they go to ICBC or the bank or land title office will say, you have to show me a grant of probate or letters of administration before I will allow you to touch the asset. And why do they say that? Because once they see that grant of probate from the court, they know that the person listed on there has legal authority to deal with the asset. So they know they're allowing the correct person to deal with it. Otherwise, if anybody goes to them and says, I am the executor, I should be dealing with this. But if the bank doesn't require a grant of probate and they allow this person to take the money or deal with it, the bank could be at risk. They could have liability, right? So none of those people, especially the government offices, will allow anything to be done without a grant of probate. So how do we get this grant of probate? So it's basically, most times it's a paperwork process. There's a lot of paperwork and forms to be filled out. It will include all the personal information of the deceased, their beneficiaries, their family members, and also we will have to provide the original will if the person had a will. Okay, so if there was a will, then the appointed executor would be applying. If there is no will, then a family member can apply, and there's sort of a listed order of preference for who has a preferred standing to apply. Okay, so once you've gone through all this, you've submitted and given out the proper legal notices, submitted all these documents to court. The court probate registry will look through all these documents. If they feel everything looks good, then they will notify you and say, okay, everything looks good. We will issue the grant of probate or letters of administration if you pay us our probate fees. So probate fees are 1.4% on all of the value of the estate. Okay? It may not seem like very much, but if you think about it, if you have any kind of tear down house in Vancouver, you're looking at bare minimum $2 million. And just for the house, you'd be $28,000. Right? So it can add up to quite a bit. So the other times when we will actually get probate is when there's a potential dispute or a claim against the estate. When we think, oh, there may be a spouse or a child out there that might challenge, then for sure we will get probate. And why is that? Because once we get the grant of probate, the clock starts ticking, right? The spouse or the child, if they want to start a claim, they have 6 months to start the claim and then an extra month to file the claim or to serve the claim. So within that time period, if they don't start a claim, then forevermore they have absolutely no claim. So we may get that probate done and hope that they don't actually start a legal action. Okay. So what are some of the negatives? We already talked about some of the negatives for probate, but a lot of it is a lot of people don't like paying extra fees, probate fees, 1.4%. It can be quite time consuming. So depending on how much time it takes for the person applying to gather all the information, and they will need all the information for all the assets of the deceased and values as of date of death. So it can be, depending on the assets, it can be quite time consuming to do that. Then once we submit it to the court registry, depending on which registry and how backlogged they are, it sometimes can take up to 2 months or more for them to get back to us. So overall, generally, I tell clients fastest conservatively is give it about 6 months to get probate. And during that time period, nobody can touch those assets. Okay? And if you have professionals helping you, it's not an expensive process to go through. There's a lot of paperwork and a lot of steps to do. Okay? There's no privacy either. When we submit these forms to court and the will to court, it is public record, so anybody really can go to the court and get a copy of everything. So that's why everybody doesn't like probate and tries to avoid it. So we talked about wills. They do not avoid probate. But what does avoid probate? One of the things that does avoid probate is beneficiary designations. So this is a good way to make sure that the asset goes to the person we have listed as the beneficiary. Okay? Outside of the will, it doesn't have to go through probate. But the downside to this is we can only do it for certain assets. We can't do it for all assets. Only certain assets we are allowed to designate a beneficiary. So the most common examples I have sort of listed there, number 3. So life insurance, right? Your registered accounts, your RRSP, your RRIF, your TFSAs, annuities, some pensions, things like that, you can designate a beneficiary, okay? And when we deal with beneficiary designations, most people will just fill out the bank form, okay, who am I designating? But sometimes you can think beyond that, especially for assets that may be a little bit higher in value. We can actually create what we call, well, for life insurance, for sure, because life insurance, usually the proceeds can be fairly substantial. We would actually sometimes create a separate legal document called an insurance declaration. So that will sort of act like a will for those life insurance proceeds. We can still create that testamentary trust that we just talked about and have that asset protection, the tax savings, and the asset management for beneficiaries, but just for the life insurance, okay? And the reason why we want it separate from the actual will is if we put it through the will, then we have to pay probate on it. And nobody wants to pay probate on something they don't have to, right? $1 million life insurance policy is already $14,000 that you don't have to normally have to pay, okay? But in order to do this, you do have to get the proper legal advice from a lawyer, a specialized estate planning lawyer who knows what they're doing and can help you get this all sorted out and done properly. So testamentary trust, so similar to what we just talked about for wills, is the same thing. These trusts only come into existence if the client passes away, okay? The assets will go to the intended beneficiaries in this case because this life insurance is designated, so it doesn't go through the will, doesn't go through probate, okay? We have the same thing, we can create that asset protection for your beneficiaries. The creditor protection if they're a professional or business owner or just get in a really bad car accident. Or if they're in a marriage or a common law relationship, okay? We can do asset management for beneficiaries. So for minors, of course, beneficiaries with legal disabilities, we definitely want to do this so that we don't have the public guardian trustee, the government stepping in to manage those assets. The other type is when we have beneficiaries who are adults but may not be very good with money. So the clients may not necessarily want the child to be in charge of their own inheritance. We may have a responsible third party managing and investing it for them. We can have some of those tax savings that we talked about. And for the insurance, you know, if we do this separately and we do it properly, we can avoid all the probate fees and costs and things like that. Now, if a lot of people, when they do the beneficiary designations, we talked about just filling out the life insurance company's form or the bank form. A lot of times I will see clients just listed their minor children. So that is something you have to be very aware of and careful of, because if you just list a minor or a beneficiary with a legal disability as a beneficiary directly and something happens to you, then those amount of money will go to the government to manage for that beneficiary. What I also see sometimes is they'll list a trustee. So so-and-so, John Doe in trust for child, okay? That would be different than this type of testamentary trust. That one is still a trust as well. It avoids the government. But what that trustee can do will be extremely limited because it'll just be based on the law. They can only do extremely conservative investments like GICs, high interest savings. They can't really do anything else besides that. And when the child reaches 19, they have to give everything to the child. When we do this type of formal insurance declaration, we can create a much more comprehensive trust. We can say the child can't take over until they're 30 or 35, the most common age I hear from clients. And we can give that trustee a lot more power to invest in certain things that are more appropriate or hold other assets or do other things, okay? But when you just have the beneficiary designation form, you put so-and-so in trust for child, they don't have any of those powers. So that was the last. So now inter vivos trust. So this is the other type of trust. So this is a trust that a client may set up during their lifetime, okay? So this is the type of trust that would exist now. We would design it, we would settle it, it would exist now. We would put assets into it now. And once it's set up, every year it has to have its own tax return. So there are many different types of inter vivos trust. So this is the more complicated side of trust planning. So I'm only going to be able to give you a very brief overview. So some of the possible benefits of inter vivos trust, and these benefits will vary quite greatly depending on what assets we're putting in, the makeup of the family, their Canadian status, all of that, okay? But these are just some potential benefits. One thing is the client, sometimes we talked about the bank of mom and dad, they may want to transfer some wealth to the next generation, but they may not necessarily want to give them control. The parents still want control. They still want to be able to take it back if the child is not responsible or has a relationship breakdown. So when we use trusts, we can actually build that into the trust itself. The client can still manage or pick who they decide should be managing those assets. Rather than gifting it directly to the child, then you absolutely lose control, you cannot get it back. Okay? If they decide to give it to their girlfriend, boyfriend, or spouse, then the parents have absolutely no control. With the trust, we do. We also get the asset protection we talked about, so similar to the testamentary trusts, right? If the child is in a relationship or they're a professional or business owner or have any kind of professional risk or liability, personal liability, by putting assets into a trust for them, it's separated, and so you get that asset protection. It's a much easier way for us to transfer assets to beneficiaries, right, down the line, right, to family, friends, or charities if some clients want to do some charitable work with their assets. With inter vivos trust, we can also avoid wills variation actions. The client puts their asset into a trust now, no longer the client's asset, so it doesn't go through their estate and their will and not subject to probate and also not subject to challenge. Okay? There's sometimes, depending on the scenario, we could get some tax savings out of these type of trusts. Right? We talked about avoiding probate. And there's certain types of trusts. We'll mention a few different types, but I can't get into too much of the details. We have limited time, and it's all very dependent on the client's circumstance. So we have one where if you're 65 or older, you're a Canadian tax resident, you can do a tax-neutral transfer of assets in. Okay. So the negatives and some of the things that we have to consider when we talk about potentially setting up an inter vivos trust for clients is normally when we transfer assets into a trust, you're considered to have sold it to the trust. So if there's a unrealized capital gain, there may be a deemed disposition, you may have to pay capital gains taxes. Okay. So there's certain exceptions to that, but that's always something we have to consider. Other things are, other fees or taxes that may be payable on transfers. If we're transferring real estate in, normally if it's a home or something like that, we could transfer it to a trust. But if it's investment, normally we do corporation rather than trust for other reasons. But things like property transfer taxes, those are things we also have to consider as well. Okay. So three main types of inter vivos trusts. We have the principal residence trust where we would normally put a principal residence home inside it. Now, a lot of the tax rules on that have changed as of October of last year. So there's much more limited use now. We used to use these quite often for where the parents were buying homes for their children, okay? But we still do them, but it's just you no longer get the principal residence exemption. That's a very, very big downside. There's only 3 scenarios where you would still get a principal residence exemption. So the uses are much more limited. We have the alter ego joint partner trust. So this is the one I talked about where you have to be over 65. Okay, you get that tax neutral transfer of assets in. You can avoid probate, avoid wills challenges. It's much easier administration. There's no time delays in dealing with assets. The client can still maintain control of their assets, but it's tax neutral. So the taxes are exactly the same, pretty much exactly the same as if the client still owned the asset personally. So we don't have tax savings, but we don't also have extra taxes to pay. Okay. And then lastly, family trust. So there's so many different uses for family trusts. Sometimes we use them as education trusts, where we put cash in to fund the maintenance or education for children, right? Oftentimes we'll use them with corporations, although now with all the potential tax changes, that may be a little bit more limited. We'll kind of see what happens there. But there's a lot of other things we can do. Okay. And if there's non-resident family members that may be gifting assets, this is a potential way as well that we can help do some tax savings, etc. But nowadays we have to consider common reporting standard and see if that is an issue for the clients as well. Okay. So other planning tools. So we have joint tenancy planning, and that's one area I see a lot of problems with. So we'll talk a little bit about that. We'll talk about cohabitation and marriage agreements. So the gold digger, son and daughter-in-law, or if the client themselves are entering into a second marriage or have a blended family. Multi-jurisdictional wills, and I'm just going to mention that there's a lot of other planning we can do with corporations and other vehicles, but we just don't have the time today. Okay. So joint tenancy planning. So this is the type of planning that we see the most problems with. So I'm a solicitor, I don't go to court, but I do have colleagues at my firm that do the estate litigation, do deal with the problems that can arise from improper estate planning. This is one thing that we're seeing more and more of. So what type of planning is this? This is the self-help type of planning, okay? This is where the person will add their child on their own assets as a joint owner, or they may put assets directly into the child's name. Okay? They think, oh, well, if that's the case, then we avoid probate, we avoid all of those issues. But there's a lot of potential risks and issues with this type of planning. Okay. First of all, for joint tenancies, we actually have two types. We have what we call, well, those are not the formal legal terms, but just for easy explanation, there's the true joint tenancy and then there's the fake joint tenancy. So what does that mean? So the true joint tenancy, a good example is when we have assets jointly held by spouses, right? So it's a true joint tenancy because it really is both of their assets, okay? They both have contributed to it, they both own it, and the real intention is that if one passes away, it'll go to the other spouse. So what is the fake joint tenancy? So the fake joint tenancy is to give you, the best way to describe it is to give you a scenario. So if let's say there's an elderly woman, she's a widow, right? She has 2 children, one in BC, one in Ontario. Okay. She decides to add the BC child on her bank accounts here. The BC child helps her with some banking. Maybe she has some mobility issues. It's harder for her to get out of the house. So the BC child helps pay bills, things like that. But she doesn't get any advice. She just adds BC child on title on their bank accounts. Okay, and now the woman passes away. So what happens with this bank account? Well, BC child's going to say, well, I helped mom do all this 1, 2, 3 ABC, helped her with her bills, cooked for her, cleaned her house, all that. So mom intended that the money in the bank account should go to me because it's a true joint tenancy. I should get that money. Ontario child is going to say, no. I also helped mom do ABC 1, 2, 3, and I helped do all this stuff in the past. So mom only added you onto the bank account for convenience, right? You were doing banking for her, so she only added you on there for convenience. Her intention is that this bank account should be split equally between the two of us. So who's right? We don't know because the mom did not document what her actual intention was. So it goes to court, right? And then basically, in reality, it all goes to lawyer fees, right? So this is what we're seeing a lot more of. And when it comes to this type of dispute, what we see a lot of are the emotions. So in certain cases, the asset, the children, when they're fighting, our litigation group, I often hear, they say, well, I tell the client it's not worth it, just let it go because you're going to pay too much in legal fees to try and get this back from your sibling. But the client will be like, no, I don't care how much it's going to cost me. I do not want my brother or sister to get it. So it becomes a very emotional thing. And as lawyers, our firm, we're very practical. We try and convince clients, well, is it worth it to go after certain things or not? But when we talk about this type of litigation, it's very different from commercial litigation where it's based on a contract, all business owners, and it comes down to sort of the bottom line, the money. But in this type of litigation, it really sometimes based on emotions. Okay. The other thing, well, the client, the person and the child may get along now, but what if the child has bad influences or they have a fight with the child? The child is on the title to the asset. So if the person wants to sell it or do anything with it, they will need that child to sign because they're listed on there. So if that child refuses to sign, then what happens, right? Without proper documentation, you cannot force them to sign. Or, for example, if it's a real property or bank account, technically the child is on there, so they could take all the money out, or they could sell the property, right? Some examples I've heard from other advisors I've worked with, a condo was put into a son's name. The parents aren't always here, and the son decided he had a new girlfriend. He wanted to impress the girlfriend. Put a big the condo was free and clear title. They put a mortgage on the condo. The bank is going to loan because there's no other charges on there. Bought the girlfriend a very, very, very nice sports car. Parents had no idea because, well, the son is on title. They broke up. The girlfriend took the car, and the parents are now helping the son to pay a big mortgage. So those are some of the risks, right? Other things, creditor issues. So if that child has any kind of creditor issues, If they are sued for whatever reason, they're a professional business owner or otherwise, or if they're in a relationship, and we'll talk a little bit more about family law, and there's a relationship breakdown, those creditors will go after the asset that has the child's name on it, okay? Because they will be considered to be the child's asset. When it comes to real property, real estate, this is where we see a lot of issues with this. People will just put children on title with them. They may have heard, oh, all these potential risks. So if I buy a property for my son John, I'm going to put myself on title on there so that he can't just put a mortgage and buy a car for a girlfriend. He needs my signature, right? But what are the issues with that? Well, this is John's principal residence. The parent has their own principal residence too. So now what the CRA is going to say is, well, the parent's 50% of John's home is not a principal residence. So it's not subject to principal residence exemption. You have to pay capital gains taxes on that 50%. And in Vancouver, we all know, in our Lower Mainland area, the housing prices have gone up so much that capital gain could be quite huge. Or other scenarios we've seen, the child becomes 19, 20, still very young. The parents decide, oh, for probate planning, we want to avoid probate, we want to avoid 1.4%. We're just going to put the child on title to our home right away. Child has no idea, they just sign. And now we've taken away their first-time homebuyers credits, right? Because they're now considered to have owned property. Okay. Other adverse tax consequences people don't realize. If the parents have their home and they have a condo, and now little Johnny is old enough, he wants to move out. They want to gift the condo to the son to live in, right? They just transfer it over. The son pays nothing, they just consider it a gift, right? So what are some of the potential adverse consequences? Well, capital gains. Even though Johnny paid nothing, the parents got nothing for the condo, it's considered to be a sale at fair market value to Johnny. So if there are capital gains on there, the parents will have to pay. And they got no money from Johnny, so there's no cash flow to pay for it. Other things, we may be triggering property transfer tax issues as well. Okay. So when we're doing the fake joint tenancy, what we call bare trust for convenience only, it's important, extremely important to have it documented. Even if it's a true joint tenancy, it's still important to document that as well, just so they're absolutely very clear what the intention was when we added this person on title or put this asset in this person's name. But one other thing is, in order to actually avoid probate, let's say the parents say, oh, I just want to avoid probate on my bank account. So I'm going to add Johnny on title on my bank account. But everything else, I'm just going to leave as is. But at least my big bank account, my investment account, will be fine, no probate. And they do the bare trust agreement that says Johnny is only on there for convenience, not really his asset. They actually do not avoid probate, because when that person passes away, when the parent passes away, when we do the probate estate administration, we have to include that bank account because it's actually not Johnny's asset. It's not a true joint tenancy. There's no right of survivorship. So that bank account gets pulled into the probate. So you still have to pay probate fees. The only way to avoid probate is if all the assets are held jointly, so there's nothing that requires probate, or everything has designated beneficiary or something of that sort. So if there's any one asset that's missed, all of it gets pulled back in. Okay. So this type of planning is very self-help. People hear it from their friends and family, oh, just do this. It's easy. You don't need to pay a lawyer. You don't need to talk to a lawyer. But they don't realize all the potential issues. Okay. So it's very important when you're considering this type of planning to make sure you get the proper advice, because otherwise you could be creating more problems. Okay, cohabitation and marriage agreements. So this is a very big topic now as well. We did have a new Family Law Act that came into BC in 2013, a lot of big changes there. So nowadays, if two people have lived together in a marriage-like relationship for over 2 years, they are considered to be common law spouses under the Family Law Act. And that common law spouse will have the exact same rights as somebody who is legally married. Okay. So clients always ask, well, why is it 2 years? I've heard shorter time periods. Well, shorter time periods are under different legislation. If you've lived together for a certain time period, shorter time period, you can file taxes together as common law spouses. But in order to get assets, you need to stick it out and live together for 2 years, sorry. what are excluded assets? So now we have this term called excluded assets. So certain things, if there's a relationship breakdown, the spouse cannot claim against, okay? What they brought into the relationship. So they're assets before the relationship, okay? Any inheritance or gifts from a third party or family, okay? And this is sort of a little bit of a gray area, but if they have a beneficial interest in a discretionary trust, then that potentially is also considered excluded. But what is not excluded is the growth of the asset. So if Johnny becomes married, let's say they don't live common law. So before the marriage, he has $1 million condo, okay, that was purchased by the parents for him. That $1 million condo, the $1 million value is exempt, but let's say when they break up, because of today's condo market, it's now worth $3 million. Right? Now that $2 million growth, his wife Jane can, or soon to be ex-wife Jane, can get half. Okay. And the other important thing about this is, in order for these assets to really be protected, it has to be kept separate. So the parents had given Johnny this $1 million condo, they thinking, oh, the $1 million at least is safe. We don't care if she can get part of the appreciation, that's okay. But let's say Johnny decides, is persuaded by Jane to put the condo into joint tenancy. He's added Jane on title with him. It's considered to be a gift to Jane, so later on it'll be half-half, okay? So any assets or inheritance, we have to be able to have a paper trail to show it was a gift or inheritance, or it was an asset before the relationship, and what the value was, okay? And it has to be kept separate, that's the key. So how do we protect against the gold digger, son or daughter-in-law, or boyfriend, girlfriend if they're just common law, right? The best way, now there's absolutely no way that's 100% bulletproof, but the best way to do it is a marriage or a cohabitation agreement. So, but this is going to be a little bit of a sticky issue, because how are the parents going to explain to Johnny, we want you and Jane to sign this agreement, not because we really don't like her, but we just think it's a good idea. So how do we do that? So that is always sort of a sticky issue, right? How do we convince the next generation that this is important? So for my practice, I actually do 2 types of marriage or cohabitation agreements. The first type is the more common one that most people will think about, right? The prenup, the American term prenup, that we don't use up here, but everybody calls it a prenup because they watch American TV. So that is, you think, okay, it's the second marriage, we cover all the assets, we cover everything in detail in the agreement, right? That's the sort of the standard agreement that all people do. But the other type of agreement that I sort of do prepare for clients is geared towards the second generation. And it makes it easier for them to accept, because what this agreement does or says is it's more of a simpler version. And it says that John and Jane are together because they love each other. Whatever their own assets are, whether their own income, their own assets, we don't care. If they have a relationship breakdown, they can fight about it in court. What they agree to is that any assets of the family, any inheritance or gifts from the family, and most importantly, any growth of those assets, they will not make a claim against, okay? So it's only the family assets. So it's much easier for the next generation to accept, right? And it makes it difficult for, say, Jane to say, I'm not willing to sign that, because, well, it's the family assets we're talking about. It's not John's assets, it's not Johnny's assets, it's the family assets. So it's sort of a little bit of a incentive for her to show that she really does want to be a part of family and that kind of thing. So that does make it a little bit easier for children to accept, okay? And it does apply on both sides usually, right? So when we talk about these type of agreements, sometimes parents are a little bit overprotective of children, and I have to sort of convince them, well, you have to think about it from the other perspective. How do we persuade that spouse or fiance to sign, right? We do have to probably offer to them that, your assets or your family assets are off the table. We won't go after you if you won't come after us, right? Some clients will, no. I want my child to still be able to claim against theirs, but I want our assets to be protected. Well, we can draft it that way, but it makes it very difficult to convince the other side that they should accept this. And you have to think about, well, the other person's parents, how are they going to think? You're all going to be one family. So my philosophy is we still want everybody, we don't want anything to happen. We don't want a relationship breakdown. So the way to approach this agreement is in a cooperative way, right? It's not a divorce. We're not talking about a divorce where we're going to try and fight everything because they're no longer going to be together. After they get married or they're common law, they're still together. Everybody's still a family. You still have the in-laws. So you want to do this in a way that makes it easier for the next generation to accept and for everybody to get along, right? So try and convince clients of that. Sometimes it works, sometimes it doesn't. But that's my sort of way of approaching that, okay? Then sort of lastly, I'll sort of mention briefly multi-jurisdictional planning, okay? So when clients have assets in different jurisdictions, which is more and more common nowadays, we have much more international families. So they may have assets in Canada. Hopefully they don't have assets in the US, but sometimes they do, and depends on how it's structured. Or they may have assets in Asia or Europe, anywhere else. It's a good idea, generally, to separate out your estate planning, because every country will have its own laws. Sometimes even every province will have their own laws, or every state. So even though a Canadian will, from a Canadian law perspective, we feel if we do a Canadian will, it should cover the client's whole worldwide assets. If the client passes away, whether or not another country, for example, China, will accept our Canadian will is another issue, right? We feel it's legitimate, it's effective, but whether another country will accept it is another issue. And also, even if they're willing to accept it, it sometimes is a lot more difficult to take a foreign will into another country and go through their process. Sometimes you need the formal translations and they're not familiar with it. It makes it a lot more difficult. So generally what I recommend for clients to do is separate out your planning. Get your planning in Canada to be done according to our Canadian laws. Separate it out. The will should specifically say this only pertains to my assets here. I may have other planning that will cover my other assets elsewhere. Okay? And the key for this type of will is that the wording in the will has to be very, very clear. The Canadian will only covers assets here. You may have other wills that will cover other assets, and the two wills will be both valid and effective at the same time. So your will, if it's in Asia, will have to have the same wording, okay? And it's very key because often when we're doing wills, one of the third line or fourth line after the name and the person's address and personal information, we usually put in the line, I revoke all my previous wills, right? To make it a clean slate. This is a new will, this is the new one, there's nothing else before, okay? When you're doing multi-jurisdictional planning wills, you cannot do that. So I had one case where I talked to the client about all this. Okay, they have a little cottage, vacation home in Southeast Asia. I told them, well, you should probably do a will there just to get it all done and sort it out. It'll go according to the laws there. We did a Canadian will. We set it out so it only covers the assets here. We have all the proper terminology. They go back, they go on vacation, they come back. They're very proud. They tell me, oh, Annie, we listened to you. We did the will in Southeast Asia, right? And here's the will, and I had it, roughly translated just so I can make sure all the terms are there. And what did I see? The third line, I revoke all my previous wills. So in effect, they canceled the Canadian will that we did for them. So it's very key that you have the proper wording, right? So we just redid the Canadian will, changed our terminology. We didn't say I revoke all my previous wills in the Canadian will, as we canceled the one Southeast Asia one, right? But we say I cancel all my previous wills except for that will, and it both work at the same time, covers different assets, etc. Okay, so that's important. The other good thing about having a multi-jurisdictional will is when you go through BC probate here, if you have a will that only says it pertains to Canadian assets, we actually don't have to list out in full detail all of the overseas assets to the probate registry. Otherwise, if it doesn't say that, you technically have to list out all of the assets overseas as well, okay, that go to the executor to deal with, right? So you may not necessarily have to pay probate fees on it. It depends on what the assets are, etc. But a lot of clients don't like to have overseas assets reported in full detail on a public record document. Okay, so that is another good benefit of separating it out. Okay, And other things, same with powers of attorney. So while a BC power of attorney could be valid, potentially in another jurisdiction if they accept it, even if it's accepted, it could also be much more difficult to do. Okay. Then lastly, just planning with corporations and other vehicles. So we just sort of mentioned, I absolutely do not have time to go into this, but there's a lot of other potential structures that we can do. Corporations are a great tool to do for investments, okay? And especially if there's businesses involved, investment properties. Okay. And then lastly, some sort of takeaway advice. So in terms of estate plans, everybody's family is different. Everybody's assets are different. Your family dynamics are different. So it's not a one-size-fits-all, okay? So when you're talking about the best sort of estate plans, they are creative, right? They should be creative. You should think outside the box. How do we sort of create a customized estate plan that fits the client? So I love what I do because I see it as a logic problem. I gather all the information from the clients. I know all the puzzle pieces, but how do I put it together in a way that is the best for the client, okay? So often it is not a good idea to listen to friends or family. They may absolutely love you, they have good intentions, but the advice that they may have heard or they may have been given by their lawyer may not necessarily fit your circumstance, right? So that is one thing that we often see is that kind of issue. We want our estate plans to be flexible. Life always changes. We try and plan for it, right? So when I do planning for clients, unless they have absolutely specific wishes that they really want documented, we'll try and make it flexible so that they don't have to keep coming back to see me and pay legal fees to make amendments. Okay. And you want to there are a lot of planning opportunities out there. Like I said at the beginning, nobody likes to pay taxes, but there are ways that we can save taxes. So you have to think about the cost-benefit analysis, right? Nobody likes to pay legal fees either, I understand that. But when I'm working with clients, it's about going through those options with them. Okay, a simple will is going to cost you a lot less. It's going to be X amount, but this is the only things we can do with it, right? These are the advantages. It's going to cost you a lot less. It's going to be simpler. But disadvantage is that you have to go through probate, subject to challenge. Okay, let's calculate what are your probate fees going to be. Is it worth it to go a more complicated route, right? Your legal fees will be higher, but your tax savings, your probate fee savings will more than cover what the cost of the planning will be. Okay, so I see a lot of people that miss out on planning opportunities because they're not willing to talk to a professional and pay some of those fees, okay? So you have to make sure that your planning is comprehensive, right? You want to take into consideration all your assets and liabilities. So if you're talking to a lawyer who's doing your estate planning, if they don't ask you or talk to you about all of your assets, all of your family circumstances, they're probably not going to be able to create the best estate plan for you, right? There's certain things, appointing non-resident executors, not sometimes the best idea, especially ones or anybody that has any US status. We really don't, we want to avoid that. Or if they have children who are in the US, right? US is a whole different ballpark, a whole different can of worms that we have to deal with if that's an issue, okay? So you want to always review your plans from time to time as well. All the laws keep changing, as everybody knows, right? And you have to take it upon yourself to review it, see if it's still the right fit, and circumstances change. Right? I can't tell you how many times I have new client come to me. They've done wills 20 years ago or 30 years ago, and I look at the will. They have 3 kids. I look at the will. There's only 1 child, right? So those type of things, it's not. If the family gets along, I mean, it can still be dealt with, but it just makes it so much easier if you update it and it's proper. Okay. And last little thought I'll leave it with is improperly designed planning is actually sometimes more harmful than having no planning at all. Okay, so a lot of people, okay, I'm going to save the lawyer fees. I have a will kit, $20 at London Drugs or wherever. I'm done. Okay, I fill it in, I'm done. Those actually can create more problems. It's almost better to have absolutely no will, okay, than to do one of those. I can sort of give you an example. There was a family that came to me for estate administration. Unfortunately, the mom had passed away, right? They showed me there was a will, right? They showed me the will. I started reading through it, like, oh, the wording is a little bit strange. So I asked them, well, who prepared this for you, right? Because it was done, there was some legal terms in there and things. It wasn't a will kit, so at least they didn't do a will kit. But they sheepishly kind of said, well, to save legal fees, a friend had their will done by a lawyer, and we just sort of took it and changed the names and added our own sort of terms in there, and we signed it. Now, I don't know, fortunately or unfortunately, they actually signed it properly, so it was a valid will, but there were a lot of issues with the will, okay? One of the examples I can give you is that there was a gift in the will to a grandchild, only if that grandchild went to university. Okay, so you can understand the grandparent, they want to encourage the grandchild to go to university, they're willing to pay for it, but that was it, just the one line, right? So what are the issues? Well, from a legal perspective, from a estate planning lawyer perspective, this is now a conditional gift, it's now a form of a trust. The grandchild is, late 20s, 30 something, has not gone to university. So most people, the family will say, well, he hasn't gone to university, so they just don't get a gift. No, that's not true. Technically, he can still go to university when he's 90, right? There's no time limit that was set out in the will terms. So what do? Is it now a conditional gift? It's held in trust until the child dies, and we're sure they won't go to university. But who's going to hold the asset for that child? And if that child passes away and doesn't go to university, then who does it go to? It doesn't say, right? Who does, it would go into the intestacy rules and all that stuff. But those are the type of issues that could arise. Now, luckily for this family, they all got along, but in the administration, it cost them probably about $20,000, $30,000 more. That wasn't the only improper term. They had a lot of other ones in there, but to make sure we got all the releases, the waivers, and made sure everything went where it was supposed to go, and dealt with all these strange and incomplete provisions. But at the end, they're like, oh, if only we had not even signed a will, it would be so much easier. We just go by the rules for distributing. We wouldn't have to deal with all this. So just to save some legal fees in the front, they actually ended up paying a lot more at the end. Okay, so those are the type of things people don't realize, right? When you do their own will, you can absolutely understand one line, I give my grandchild this amount of money if they go to university. You think, okay, that's it. But from the legal perspective, estate plan purpose, there's a lot more things that the client may not realize. So sometimes it is definitely worthwhile to get the proper advice. Okay. Okay, so I think we'll take questions. And I don't know how many questions we have, but if we don't get through everything, feel free to contact me if we don't get to your question, or if you want to have follow-up questions. Okay, so cost of setting up a trust, it will vary quite a bit. It's the same thing as when you get a will done. If you're going to come to a firm like Fasken, we're a big firm, but we specialize and we know what we're doing. We can create more value for clients. We do spend a lot more time with clients versus if you, I always pick on the lawyers in the malls, sorry, but like if you go to a lawyer in the mall, you go in, you walk out with a will all signed and done in 45 minutes, right? I spend about 2 hours with each client in just the first meeting. So with trust, it's the same thing. You will have smaller firms, sole practitioner lawyers that will do trust as well. And they will obviously charge a lot less than your downtown firms who are more specialized in this area. But same thing with a lot of things in life, you get what you pay for. So it depends on your philosophy and your perspective, right? Do you want something that's a little bit more comprehensive where the lawyer has gone through everything with you and we've set it up to give you protection, right? One of the things I do with my trust, I separate out into time periods. If the client is their own trustee, during that time period, full flexibility, they can do whatever they want, they can change terms. But if the client is now gone, we now have a backup trustee, maybe one of the children. Now what I do is I actually limit the powers of what that trustee can do. Because if you still give them full reign powers, well, technically that child could go in there, change all the provisions so that they get everything and their siblings get nothing, right? So those are sort of additional extra things that we talk to clients and everything about. So in terms of a cost, it can vary quite a bit for a setup of a trust, and it depends on the complexity of the trust and what type of trust you're setting up. Okay, trusts and wills are going to be a little bit simpler. Trusts are inter vivo, so we have a lot more things we have to think about. What assets are we putting in? Who's going to be trustee? Who are the beneficiaries going to be? Are we looking at tax savings, things like that? But anytime you're looking at an inter vivos trust, to have a properly set up trust that's comprehensive, you've done it through a specialist, you're probably looking anywhere from $6,000 to $7,000 to $10,000 to $20,000, and that's a domestic Canadian trust. Offshore trusts are an entirely different ballpark and much higher fees. So that is give you a general idea. In wills, it really varies, depends on how complicated you want to do it. So it doesn't vary depending on your asset level. A question I get a lot from clients. I don't have very many assets, so you don't have to charge me very much, right? Well, no, it depends on how much you want me to do. It's fair, right? Some of the most complicated planning I do for clients is not necessarily my highest net worth clients, but they are usually the clients with the most complicated families, okay? The blended families, the children that don't get along with the new spouse, and there's other business assets involved. That's when we do planning to avoid all the disputes down the line. Okay, so they may not be my highest net worth families. My highest net worth families, if they're a nuclear family, everybody gets along, then sometimes we can get away with simpler planning. But the most complicated families, those are the ones that we do the most complicated planning for to avoid lawsuits down the line. Okay. Yeah, so it can be as well. Right, depends on what type of trust we're talking about. If we're talking about wills, right, the inheritance trust that we're talking about, if you have children who are minors or beneficiaries with legal disabilities, you definitely want a trust. Doesn't have to be very complicated, but unless you want the government handling the money or the assets for the child or the beneficiary with a legal disability, you definitely want a trust. I always get asked, well, how much asset level does it make sense to make a trust? There is no specific, cutoff, because obviously the more the assets, sometimes some of the benefits are more, right? Tax savings, things like that. So it may make more sense to do a trust. But like I said, it comes down to how complicated sometimes the family is. If they're a blended family and there's going to be a big fight, then we certainly would do trusts, because that $10,000, $20,000 to do a trust could avoid a $200,000, $300,000 lawsuit down the line, right? And even with the lawsuit, what it means is that the client has absolutely no control over what the court orders. It could go to somebody they didn't want it to go to, right? If we do the trust or other planning, then we would be able to make sure it goes where the client wants to go, okay? So there really is no set cutoff. They can be quite valuable for everyday people as well, not just the uber wealthy. We talked about some of the trusts being able to avoid probate. Even a home that is $2 million, just on the home itself, if we do a trust, you're saving $28,000, right? Not to mention all the other assets that potentially could be in there, right? So there is a cost-benefit analysis that we have to look at. In terms of ongoing costs for a trust, I think that was the last question I didn't answer. It depends on the type of trust. If you have a professional trustee, there are annual professional trustee fees. If it's yourself, the client themselves are managing, you're not going to charge your own fees. There is a tax return that has to be done every year, so the cost of that will depend on how complex the tax return is, right? But the ongoing cost is not going to be hugely substantial, okay? The biggest cost of a trust is the designing and implementation, and that's a one-time fee. Okay, so I knew this question was coming because it's a very hot topic right now. With all the proposed changes to corporate tax and all that. We don't have time to go into all the details, but right now, at least for us, we are on a wait and see what happens. That's what we're telling our clients, because we don't know. Hasn't been implemented yet. They do have draft legislation. We sort of see what they're trying to aim for, but there is some uncertainty. There's been a lot of pressure to change or amend or not implement these changes. So we don't really know what the government is going to decide. And so it's too early for us to do any planning for clients. But we just kind of tell clients we're keeping on top of the changes to see what sort of happens down the line. And we always send bulletins and things like that to our clients to update them. And then once we sort of know what is going to be implemented, then that's when we'll start talking to clients about what makes sense for them. Okay. But other than just taxes, there are other reasons to use corporations, right? The limited liability and other things like that. So it's not just to save taxes, so it will depend on the client's circumstance. If the personal liability is a big issue, potential risk, like professionals, things like that, then if that is a big concern for them, then they may still keep their corporation, right? Versus the tax savings. So sometimes it's not just all about the tax savings. Well, the example is when we submit probate on the form itself, it has detailed personal information, and we also submit the original will. Right, so personal information includes birthday, all the full name, everything for the deceased person. Also includes a list of all of the assets that go into the estate, account numbers, the value as of date of death, real property, the address, and all of that, mortgage amounts, all of that goes on there. So that all becomes public record. Because it's a court file, right? All becomes public record. So, and whatever you have in your will becomes public record as well. Once we get the grant of probate, there's a certain time period for the person or who wants spouse or child to challenge. They can't challenge before the will is probated, but once it's probated, they have 6 months to bring a legal action and then an extra month to serve the notice. So if you get the grant of probate and after 7 months you don't see anything, then you're safe. Okay, but if something happens, then you know that there's going to potentially be a fight. So again, in BC, it's spouse and children. And when we say spouse, under the new rules, there potentially could be more than one spouse, right? You could have the legally married spouse if the person has 2 families, right? There could potentially be 2 spouses. If you have no will at all, there's what we call intestacy laws. So they set out very specifically what happens to the assets. Now, I'm not saying that's the most ideal. I'm just saying with a bad will, it can create more problems sometimes than intestacy, because intestacy, nobody can challenge. It's based on the law, the formulas. So what the intestacy laws say, if the person has no will, we look at who the surviving family members are. If there's only a spouse and no children, then everything goes to the spouse. If there is a spouse and children, under our new, we call it WESA for short, but it's Wills, Estates, Succession Act that came in a few years ago. We look at more modern families. So we look at whether those children are the common children of the spouses. If they are the common children, then the spouse gets the first $300,000. Then anything over that, the spouse gets half, the children share half. Doesn't matter how many children you have. The old laws, we looked at number of children. New laws, it doesn't matter. You could have 10 children, they would only share that half. If they're not common children, the spouse gets the first $150,000 and half of any remainder over that, and the children share the other half. Okay. If there's no spouse or children, then it goes up to parents. Then we go to siblings, okay? Nieces, nephews, but after that, it goes to the government. Okay. But other family members, I mean, they're not fair. They're fair. They won't just take it and run, so to speak. But if there are other family members that come forward, they can petition the government to get the estate and stuff. But that's what would happen on intestacy. There is no, like I mentioned before, there is no minimum asset amount. But this is where when you're talking to a lawyer, we will go through with the client. These are the benefits to having an inter-vivos trust. These are the disadvantages. This is what it would cost you based on what you want to do, the terms you want to have, who are your trustees, things like that. And the client will have to make a decision whether it makes sense for them. Okay. As I mentioned before, if you have a very, very cooperative family, everybody gets along, it's the first marriage, then we may look a little bit more at asset value, right? How much can we save in probate? How much can we save in taxes? Does it make sense? Okay. But if you have a complicated family and we know, okay, the parents are trying to cut out a child who has left and never come back, or it's a second marriage, we're worried about everybody fighting if the client passes away, then we may not necessarily worry too much about having enough assets in the trust. A lower amount of assets may make sense because we want to avoid disputes, right? So that, it can vary. There is no specific cutoff. Okay. So what we talked about before, if they're common law, what they sort of bring into the relationship is off the table. So she keeps it separate. She doesn't add his name on it. The sort of the value that she brought into the relationship is protected, but you know, the growth in the value during the relationship, when they break up, that growth in value is going to be subject to 50-50 claim. So he doesn't get 50-50 of everything. It'd just be the growth. But you know, practically she has to keep it separate. If she adds his name on it, and then it's for sure 50-50 everything.
I have two adult children, one in BC, one in Montreal. Is there any special things to pay attention when making a will?
So when you have, that's fairly straightforward because all your children are still in Canada. The thing to consider when you're doing estate planning is when you're picking executors or powers of attorney. Is your child in Montreal going to be a good fit? Because as I mentioned, if you appoint both children together because you want to be fair, it means that if you lose capacity or if something happens to you, you pass away, both children have to act together. Both people have to sign. They both have to make decisions together. So same with any other decision on appointing executor or power of attorney. Are they able to actually manage it for you? Are they too far away? Okay. Do they have the time? Are they responsible? Are they trustworthy? Right. Those are all considerations. And if it's two children or any two people together, can they make a decision together? Right. If they can't, then it's a deadlock. Then it goes to court. If they can't get along, if your children don't get along, then don't appoint them together. All right. So those are all considerations to sort of take into account. But because they're both Canadian, then it's not as big of an issue. If we're talking about one child in BC, one in the US with a green card or other form of US status, then that becomes much more complicated. Okay, so when we do the probate fee, so this is something when I do planning for clients, I will go through with them as well. These are the expenses that will be payable when you pass away. Is there enough cash in your estate to pay for it, right? Particularly a lot of my Asian clients, I have to say, they really like real estate. So, but real estate, it can be a good investment. I mean, I'm not a real estate realtor or anything, so I can't comment on the market, but the only issue with real estate is usually it's not very liquid, right? It takes time to sell, or if you do a fire sale, you're not going to get a very good price. So those are all things that we consider when we do estate planning for clients. When we have to go through probate, that is one of the potential issues. Your assets are basically going to be frozen. There's certain things that if there's a bank account, there's cash in it, that the bank will allow to be paid. Probate fees are one of them. So if there's a bank account that has enough cash, then when you give the bank the document from the court that says this much in probate fees are payable, the bank will issue a draft payable to directly to pay the probate fees. They won't issue it to you, but they'll pay it directly for that, or income taxes. They will pay it directly to the government as well, okay? certain big expenses, if there's funeral expenses, things like that, they will allow money to be taken out, but you have to have the formal receipt and they will only cut the draft or whatever to that other third party. So there is some leeway, but you have to think, is there actually enough cash, right? So sometimes life insurance or other things that are designated beneficiaries that go outside the will may be a good way to get some cash separately, or we might do planning just to avoid probate altogether. Yeah, so with beneficiaries with the legal disability, we do have to be very careful in the planning that we do. So it depends on what the parents want to do. Sometimes if they want to just go simple and do a will, then we do want to set up a trust for that beneficiary with a legal disability. And we would do it in both parents' wills because we don't know who's going to go first or if it's a common accident. So we want it in both wills. It's not going to just be in one, right? It doesn't make sense. And we have to be careful that we're aware of the requirements and the restrictions for somebody, a beneficiary with a disability who is receiving government credits. We want to make sure that the way that we set up that trust or transfer assets to that beneficiary do not take away from their government benefits. So there are always those things that we have to consider, okay? The other thing that we could do is to set up an inter vivos trust, because for some of my clients with children with disabilities, they may have one child with a disability and one without. So depending on the clientele, sometimes they may think that, okay, the child with a disability may need a little bit more help. They may need more assets, or actually some clients are a little bit more practical. They are a little bit higher net worth. They know, well, my child with a disability may not need that much, right? They just need enough to make sure they live comfortably. So I might give a little bit more of my assets to the other child who may, have their own family, or they may, to start their own business. But in those scenarios, if you use a will, you have to be very careful that when you have a beneficiary who's a minor or a beneficiary with a legal disability in a will, then even if you set up a trust for them, you still have to give notice to the public guardian and trustee, the government. And the government will take a look at that will and see if that minor beneficiary or the beneficiary with a legal disability got their fair share. If they don't think they got their fair share, they will start a legal action on behalf of that beneficiary. So those are all things that you have to take into consideration when we do planning for beneficiaries with legal disabilities. Other option is, most people may have heard, like the RDSP accounts. Those are good ways. There's restrictions on what we can put in, but there are matching programs, so it's a good way of doing some planning there too. I know everybody always wants to talk about taxes and capital gains. So in terms of that, it depends on what that property was. If it was a principal, let's say it's a parent passing it on to a child, if it was a principal residence of that parent for the whole entire duration, then, and it falls under the principal residence exemption. So the parent, let's say when they bought it, it was 1 million, when they pass away it's 3 million. So as long as it's the parent's principal residence for the entire period, it qualifies for the principal residence exemption, that $2 million gain is exempt. Right, when the person passes away, they have to do a terminal return. You're considered to have sold all your assets at fair market value, but there are exceptions, right? Like principal residence exemption, you don't have to pay taxes on that. So then it goes to the son. He will get it at the cost of $3 million. Okay, so if he now lives, he rented out and he decides to sell it later on, 2 years from now, it's now worth $4 million. Only that $1 million gain is taxable to the son. If he decides to move in and it now becomes his principal residence, then if he can use his principal residence exemption, then it's exempt too. But the taxes are payable from the estate. It's actually not payable by the son. Okay. It depends on how the paperwork is done and the timing. It's very, very key is the timing. So the son can technically renounce the gift, right? Say, I don't want it, but he has to do it, pretty much right after the estate, right? You don't want to be transferring it or having dealt with some distribution, et cetera, then the son doing a renouncement. The earlier you do it with proper paperwork, then it is going to be most likely, I mean, I can't speak for the CRA, but most likely if you have all the proper paperwork done, it does make sense because he's just given up on the gift, right? It has not gone to him, it's gone to the mom, right? So it should still qualify for the spousal rollover because CRA is going to know when the mom sells it or if the mom passes away, they're going to get their tax, right? So it's not that we are avoiding all the tax, unfortunately.
So even the date the son signing is after the father's passed, the date he passed.
Yes, because I mean you can't sign it before, right? So
it should be acceptable, right? Yeah. Thank you very much.
It just has to be done properly.
Anybody have any questions? Last call. Okay, if not, we thank you very much, Annie, for today's seminar. Let's give her a big round of applause.